This is Too Many Lawyers. I'm your host, Royal Oakes. Connor's on special assignment, which sounds very important, doesn't it? This week, a conversation with one of the top employment lawyers in California, John FAGERHOLM, managing partner of the Glendale law firm of JWF Law, also known as Employer Lawyer LA. Now, if you have a problem with the boss, John's not your guy. He represents employers. We talk about what it's like to litigate employment disputes in a one-party state like California, where the party in charge is not friendly to companies. Here's the conversation. Hope you enjoy it. We're talking with John FAGERHOLM. He is an LA-based attorney, founding and managing partner of the firm JWF Law, or Employer Lawyer LA, based in Glendale, California. Talking about his work as a lawyer representing companies, employers in the employment context. John FAGERHOLM, appreciate you being on Too Many Lawyers.
Oh, yes. Thank you for having me, Royal.
I guess one question is, before you even get to the jury trial, as a lawyer representing employers in employment disputes, whether it's harassment or termination or whatever, are there things that you can do on the way to the jury trial that can help short circuit the case? And I'm thinking from my experience, I did employment law, but more than that, I did representation of life and disability and health insurance companies in first party bad faith cases where the company would deny the claim, somebody would sue for the money, and they'd say, I want punitive damages, which they have a right to seek if it's the tort of bad faith in California. And that just, totally gives the willies to insurance companies. But there are motions you can file. You can file a motion for partial summary judgment in federal court or summary adjudication in state court to knock out the bad faith aspect and or the punitive damages aspect that sort of cuts the case off at the knees. Are there similar approaches that you can take in the employment law context to try to inject some reality here and maybe get the judge at least partly on your side so that you're not held up for an extortion settlement?
Uh, yeah, I mean, obviously, I don't want to give away, strategy because we have a very specific strategy. But I would say that if everything goes perfectly, well, let me start with another thought. If this is a real claim, you shouldn't be trying it anyway. Those are my thoughts.
Right.
Okay, you did something wrong. Let's get out of this because it's not going to get better in front of a jury, right? If you didn't do something wrong or what you did was minor clerical errors, I mean, people don't realize they get sued for that too. Then I say being aggressive up front is very important. Well, if you're getting sued for something you didn't do, that's a bad actor anyway, and I think juries see through that. Right. Juries see, they may go into it not liking the employer because of their own biases. But once you get into the case, they kind of decide who they like and who they don't like. And, people taking advantage of the system, I think most citizens don't like that. Right. And I think the key strategy is to be very aggressive up front. So what we try to do is, along with the answer, we start out with an answer, a cross complaint if we have it, because a lot of times if it's a bad actor anyway, they probably did something. And if we have a cross complaint, we file a cross complaint at the same time. That's a good strategy to get to settlement because opposing counsel's options are to defend that cross complaint for nothing because their client isn't paying them up front, or do nothing and let either the client pay for it or take a default judgment, right? Then we send out a first set of discovery. We try to do a deposition right away because if it's a bad actor, everyone thinks that they can stand up to deposition, but I've seen very few people that can lie in a deposition without you knowing that they're lying. And then we try to do a CCP 998 pretty early if we can. And for those non-lawyers out there, that's a statutory offer to compromise. And why that's important is you give a number that you think the value is, and it's usually a lower number than the other side thinks, and they're always going to reject it. But if they reject it and they don't get as much at trial, then the legal fees are cut off from that point.
Yeah, and
So
the big factor there is expert witness fees as well. My recollection of 998 is that if the other side says no to your 998 offer, and then as you say, you go to trial, they do worse than what you offered, then you get to collect expert fees that you wouldn't otherwise have been able to collect, which could be tens or even hundreds of thousands of dollars.
yeah, so it's a really powerful tool, and it's always this nagging thing that's out there. So even if we do that early, 6, 7 months in, that's always there. And then we always focus on moving the case forward as if we're going to do a summary judgment, even if we don't have one, because it just seems like a better way to be prepared for trial. And then, of course, the best tool in the quiver is mediation. Really setting out a good mediator's brief, and we write our mediation briefs as if we're writing a summary judgment motion, because by then we should have everything we need for a summary judgment motion. And then and then we just fight hard at the mediation to convince the mediator, to convince the other side that this is worth X and not Y. And that's the basic strategy.
I want to follow up on a couple of points you made. First, about depositions. In my experience, John, there was a lot of pressure by my clients, insurance companies who got sued for bad faith. They wanted to be very aggressive. They wanted to run in there, take the deposition early, and really, grind down on them and convince them they got a terrible case. And I had to fight back because there's an old expression: deposition is trial. I found that if you wait until later in the litigation, when you've gotten a lot of written discovery under your belt, subpoenaed some information, you're able to really focus on the plaintiff's deposition and score some great points that you just put in your little bag. And now, if you're at trial, you can use those points to hammer people over the head, or in the mediation context, you use it. And so I was always pushing back saying, I want to wait a year or more. What is your philosophy on that? It sounds like you're more the kind of guy who wants to get in there and blast away, take an early deposition.
Yeah, I like to take early depositions because I want the plaintiff to understand what they're doing, because basically they go to a lawyer and they're like, oh, they're going to take care of everything. This is just free money for me.
Right.
A deposition lets them know that, number one, this isn't free money. It shows them the pressure that they're going to be under. And also, the goal is always to get rid of the case as early as possible. I also want to show the opposing counsel how terrible their client's going to be in cross-examination at trial. So I prefer to take them early, but again, we do want our discovery responses back before we ever depose, but we just try to do it on the front end of the litigation and not the back half of the litigation.
The other point I wanted to follow up on is you mentioned mediation. It's such an intriguing issue to me. Starting in the late 70s, as I did, mediation was basically unheard of. You had some superstars on the Superior Court bench who were known as the guys who could really twist arms and settle cases, and they were given that job as to try to handle mandatory settlement conferences. And then in the 80s, the concept of mediation arose. And for non-lawyers, if you go to trial, then the judge or the jury says you win or you lose. If you go to an arbitration, the arbitrator says you lose or you win. But if you go to a mediation, nobody forces you to do anything. It's just somebody, usually a retired judge, but sometimes a lawyer who just would rather be a mediator than a judge or a practicing lawyer, who tries to twist arms. He goes into the room with the plaintiff and the plaintiff's lawyer and tries to get them to come down and be more reasonable. Goes into the other room with the defense and tries to get them to come up and be more reasonable. For my practice representing insurance companies, it became absolutely the coin of the realm. I mean, we wouldn't think of litigating a case without having mediation on the docket. And of course, a lot of judges insist on it. What is your experience in terms of mediation? Is it generally successful? Do you use the same mediators over and over, or do you kind of spread it around?
Uh, I like mediation because if nothing else, it's a good tool to show your client what it's going to be like, or what the value of their case is. Because I can tell them whatever, but to have a third person neutral telling them, "Hey, this isn't a $5,000 case. This is a $50,000 case or a $500,000 case," means a lot more coming from a third person, like you
Right.
said, retired judge. Uh, my thoughts on mediators and whether it's successful or not. I would say about 60% of the time you get out of there with a deal. The other 40% of the time, I don't think it's a waste because, we ask for a mediator's proposal and then we at least have some brackets that we're dealing with, and then we can keep pushing. And a lot of times, mediation is unsuccessful. You get to the eve of trial after litigating for another year, and then it still settles for around what the mediator thought it would should settle for, right? So it kind of gives us a good indication of what's going to happen. And it usually just depends. Sometimes it's our client that's not willing to do it, and sometimes it's the other side that's not willing to do it.
In your experience, do cases settle at the first crack at mediation, say 50% of the time, or more like 75%, or close to 100%?
Well, that's what I was saying was more like the 60% of time, and it really depends on the mediator. There are really good mediators, and then there are just mediators that they're there, they're getting paid, they're not trying to settle anything, and I'm not even sure why they're mediators. You have to be really careful. We have a handful that we like, but unfortunately, the other side has to agree to it also. And there's a bunch of mediators in LA County that are just so pro employee, and of course, that's who they're going for. And those guys, we
Wow, if they've
always
got that reputation, how could they get business? Because why would anybody on the defense agree to them?
Well, you have to use them at least once to figure it out, right? And then
Right.
I've been doing it long enough where I kind of know. But you also will get a clue because there's a handful of guys, a handful of opposing firms I deal with all the time, right? So this
Oh,
is
yeah.
all they do, and there's certain mediators that they like, and they insist on it, and you got to fight with them not to use that mediator. So that's a plaintiff side mediator, and so you
Yes.
don't want that.
Did you have you ever bumped into a couple of mediators named Rob Kaplan well, I'll just start with Rob. Have you bumped into him?
Yes, have used Rob Kaplan. I don't know the last time we've used him, and I don't think I've been in a mediation with him, so I've just seen that we've mediated with him.
So I mentioned his name because he and Jeff Krivas were like the superstars from the insurance uh, company's standpoint for bad faith litigation in the 80s, 90s, 2000s. But they were popular with plaintiffs' lawyers as well, and that was the key. They had street cred because they used to be plaintiffs' lawyers, and so the plaintiffs knew that they were good guys. But they were so good at twisting arms on both sides, including the plaintiffs' lawyers, that I got to the point where my clients, if I couldn't get one of those two guys, they were really unhappy, and so we would just wait. I will. You said there are some bad mediators. I'm going to tell you a quick horrible mediator story. I challenge you, John, to come up with a story of a worse mediator. So I had a life insurance case for MetLife, and it involved a life insurance benefit of about $500,000. And so the guy died, and the widow sued for bad faith because the company wouldn't pay. So we hire a mediator, and this mediator used to be on the California Supreme Court, John. Very, high level, elite level attorney, right? So now and justice. So now he's the mediator. My client is an in-house lawyer from MetLife. He flies in from New York for the purpose of this mediation. It's going to last what, 4 hours, 6 hours, a full day maybe. Flies in just for this purpose, and he happens to be black. So the mediator comes in and he says, "Oh, hi. I've looked over the briefs. I got to tell you, here's the deal. I think give me 250 grand. Give me 250, and I'll get this settled." And we say, "Whoa, whoa, 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 Your Honor," because you got to call him Your Honor, even though he's not on the Supreme Court anymore, because he earned it. He went up to the Supreme Court. We say, "We really like our case, okay? I mean, we're not just blowing smoke. We really like it, and so we want to settle. We'll give you 50 grand. We're not going to tell you how high we're going to go. That you never do that. But that's what we want to do." He pushes back. He says, "No, no, no, no. Give me 250 and I'll settle this case." We're thinking, I think the guy probably came out with maybe 150 or 200 total because we really did like the case. And so we say, "No, we really want to start with 50. He says, "If you start with 50, the other side is going to take it as an insult and they're going to walk." And I'm thinking, I've done like 300 mediations. Nothing like that has ever happened, okay? And here this guy rides in from the Supreme Court and is telling us this crap. And so we say, "No, thank you, Your Honor. We'd like to start with 50. And he looks at my client and he says, "You're wearing the black hat." Okay, that's an interesting metaphor. He repeats it. He says, "You're wearing the black hat here." And my client, if I could repeat, was black, okay? And what is it? Clueless. So we say 50,000. He says, fine. He goes out. He comes back about 3 minutes later, and he says, they took it as an insult and they're leaving. And my head is spinning, my jaw is dropping, everything, many body parts are being affected by this. And I say, really? And he says, yes. And I'm leaving too. Goodbye. So I walk out in a daze into the hallway. I walk down to the plaintiff's lawyer's office and I say, hey, what just happened? And the plaintiff's lawyer says, well, the mediator came in and he said they're offering 50. If I were you, I'd take it as an insult and leave. I said, you're kidding.
That's crazy.
So I scoot out to the reception area and I say to the receptionist, has he gone? And she said, oh, yeah, he's leaving. Yeah, it's his birthday today. His family has a birthday dinner planned. Oh, really? And it's still like in the morning. So I go back to the plaintiff's lawyer. We talk. I explain what happened. I try to let him know that I think we're dealing with a mental patient here, not the receptionist, but the justice. And so we talk. We try to settle it on our own. We can't. We settled it a month or two later. That's my worst ever story. So I've issued a challenge to you.
Yeah.
Can you top that story?
No, I can't top that. That is really bad. I mean, I've had a mediator take our number, go in, what seemed like hours, and then come back and just say, hey, I don't think I can get this settled for you.
Yeah. Well, that's
And it's like, well,
discouraging.
wait, what are we paying you for?
Yeah. What we're paying
After
for it.
one round
Yeah.
like this, right? Why are you wasting our time? And then the only other odd one that I had was we were mediating, and the other counsel and I just didn't like the guy. I didn't like him
Well, that's not
because
uncommon. We on the defense side, we often develop strong dislikes for plaintiffs and lawyers, and I'm sure they feel the same way about us in many cases.
no, but he was just so smug, and I just disliked him.
Right?
But I liked the mediator. And then we were stopping for lunch, and I walk across Ventura Boulevard or whatever boulevard it was, and I pop into this little restaurant to eat by myself because my client had to do something else. And I look over, and him and the mediator are eating together.
No.
Yes, and I was like,
All
"What?"
right. Well, I'd say that's about as good as my story. So
Yeah.
we
So
both have
so
that.
I walk over there and I go, do you guys mind if I join you? And they just look shocked, right?
Well,
And
what
then I
can they
sit
say?
down. Well, they said sure. And then I sit down with them and I say, hey, this is really inappropriate. And I start having that conversation with them.
You weren't referring to the entrees they ordered.
Yeah, yeah. And to his credit, he did get it settled, and he got it settled for a number that we liked. But wow, that was, there was no indication that they knew each other previously or anything,
Right.
and apparently they were friends. But I
Well,
have a
some.
but I,
Go
but I
ahead.
have a bad federal judge story for you, and I won't say
Okay.
his name. And this just happened recently. We had a default judgment, a motion for default judgment, in which I have emails from the defendant saying I'm accepting service, everything else. My answers due on the so easy default.
Right.
We show up for the default motion, and the defendant shows up on his own, and he says, "Oh, I have an attorney, but I haven't retained him yet."
Well, so that you don't really have an attorney, do you?
Right. And then he says, the judge says, who's the attorney you're retaining? The judge hears the name, and he's like, "Oh, that's my golfing buddy."
No.
So I'm not gonna. No, it's in open court. That's my
Oh,
golfing buddy. He's a good guy.
oh
I,
my.
I I'm not gonna grant the default. Come back in a week.
Oh my gosh.
Yes. Then we come back in a week, and we start talking or whatever, and he's clearly gonna overturn the default, even though there was no reason to overturn the default. The guy didn't answer in time. The guy got service. There was none of those issues. So he says he's not gonna grant the motion for default, but then hints to his buddy, "Hey, I think the pleadings are deficient in the complaint. So why don't you file a motion to have this dismissed?"
Oh my goodness.
Open court, by the way.
Well, the bottom line is the judges, we like to think that they're wonderful and biased and unbiased and smart. They've got the black robe. They are literally above us, a few feet high. And, so we want to have confidence, but then we realize, oh, yeah, every single judge, with a few exceptions, every single judge was appointed by a politician. We don't like politicians very well. We don't have a high regard for a lot of them, but that
Yeah, that was interesting. And the other funny part about this case is he retained him. They obviously got the motion to dismiss because the judge was his buddy, and then the attorney dropped him. So then he ended up giving it to us later anyway.
wow,
Yeah,
amazing.
yeah.
We are talking with John Fagerholm. He's the founding and managing partner of JWF Law, also known as Employer Lawyer LA, based in Glendale, California. Last topic I wanted to get into was what do you do as an employer when you got an employee you're not real fond of, but you know you're likely to get sued if you take adverse action? And you know the advice you hear about is paper trail documentation. What do you say to employers when they ask, well, just how fast can I do it, and how much documentation does there have to be? And it's so uncomfortable. If I document it, they probably have to know about it. What's the drill in terms of creating a good paper trail that will help you in court?
Well, I do agree. I think documentation is better than anything. And also, if it's a real problem client, I say document differently, right? So sometimes it's a client where you can write them up and say, "Hey, here's what you did wrong. Here's a corrective action," or something like that. Sometimes you can't. So what I suggest is send an email to the manager, to a partner, to someone else, and say, "Hey, Robert is late for the 12th day in a row," or whatever it is, right? So at least there's record of it, even if you're not going to tell Robert, if you're not going to scold Robert. And the reason why you wouldn't scold Robert is because I want to clarify adverse action. So firing someone isn't an adverse action, at least according to the law. The adverse action is if you're retaliating, right?
Right.
So in California, one of the brilliant laws that is anti-business is if the employee complains about anything, even if it's not true, even if it's not actionable, like, "Hey, whatever, the floor is slippery and I almost fell," or whatever it is. If you fire them within 90 days, it's presumed retaliation. Now, that's a rebuttable presumption, but you're going to have to spend the money to rebut that. So
Well,
that's why sometimes I don't
what
believe
an
in the
idiotic
warnings.
law. What possible excuse could there be for that statute?
Well, so plaintiff side attorneys have something to
Yep.
sue about,
There you
right?
go.
And then they because all you need to give them is enough to sue, because then you have to settle if you're a smart business owner.
Hmm.
See, so that's why that law is there. The other thing, what you were saying about how to get rid of a bad employee,
Right.
sometimes you just have to fire people, and it's just worse to not fire them. What I suggest as an insurance policy is uh, a severance agreement with a general release of all claims. That's the best you're going to do, and it stinks to pay extra to a an employee who's already caused you problems, but it's exponentially more expensive to have to then fight an attorney for this bad employee than it would be if you just gave them a couple weeks severance.
All right, good stuff. John Fagerholm, thank you so much for being on Too Many Lawyers. I've tried to give a little plug or two for your firm. What about other stuff? Any writings or podcasts or anything else you'd like to mention for folks to follow you?
Yeah, I've got a podcast. It's Lawsuits and Lessons, and it's a lot more about being an entrepreneur than it is about law. To be honest with you, but we try to incorporate. We bring on entrepreneurs and we ask them questions. They tell their story, and then we ask them about lawsuits and legal issues that they've been in. And then the only other thing, because I'm very focused on my law firm, is I have a site called Defend My Biz. It's new. It's defendmybiz.com, and it's going to be set up in a way that business owners can go to it and find resources to help them with troublesome employees.
Excellent. All right, well, check out Defend My Biz. John Fagerholm, thank you so much. We'll see you again, I hope.
Yeah, I really appreciate it.
You bet. Thank you.